Straight ahead on Law and Crime Daily. Police open a new investigation into Lori Vallow Daybell. Did she kill one of her ex-husbands? New recordings raise questions.
Also, attorneys seek to move Scott Peterson out of San Quentin prison and into a county jail as a judge decides whether he deserves an entire new trial.
Plus, the couple who aimed guns at protesters outside their St. Louis mansion file a lawsuit against the photographer.
And voters choose police reforms on election ballots in several major cities. Law and Crime Daily covers court cases from coast to coast.
And welcome to Law and Crime Daily, everybody. I'm Aaron Keller. Brian Buckmire is here with me. Terry Austin is off today. A newly released audio recording of the so-called doomsday cult mom, Lori Vallow Daybell, is leading investigators to look into murder allegations. Vallow is charged with conspiracy to conceal, destroy, or alter evidence after the bodies of her two children turned up buried in a property belonging to her fifth husband, Chad Daybell. Authorities are investigating if more deaths could be tied to the couple. An audio recording of Lori Vallow from an informal meeting about religion in October 2018 was provided to East Idaho News, which in turn shared it with Law and Crime. In the recording, Vallow talks about her third marriage to Joseph Ryan, the father of her dead daughter, Tylee. Lori Vallow is heard making accusations against Ryan during a custody battle and then cites passages from scriptures used by the Church of Latter-day Saints.
I went through a lot of years of this kind of hard stuff, and I was going to murder him. I was going to kill him, like the scriptures say, like Nephi killed him, just to stop the pain and to stop him coming after me and to stop him coming after my children. And I just felt I couldn't take it anymore. And I would go through the scriptures and find all the things like, if he comes against you once, if he comes against you twice, if he comes against you 3 times, then you can kill him. It says it in the scriptures in the Book of Mormon. I was like, there it is. There's my answer. I don't want to do anything that's wrong. I did not have a murderous heart. I just wanted to stop the bleeding.
Law and Crime Executive Trial Producer Cathy Russon has been following this case since the beginning and explains the custody battle.
From 2004 till Joseph Ryan's death in 2018, it was a contentious custody dispute. That many years. I have read all 1,800 pages of their court documents on the child custody dispute, and it's nasty. And Lori accuses Joseph Ryan of raping her children. And he took lie detector tests. He was interviewed by psychologists. It was determined by the courts that this just didn't happen. So in April of 2018, Joseph Ryan is found dead in his apartment, and the medical examiner determines he's been dead about a week and that he had a heart attack. Well, this recording was 6 months later, and it was 1 week before she met Chad Daybell. And she's talking about how when she's going through this battle with Joseph Ryan, she wanted to kill him. She wanted to murder him. She just wanted the bleeding to stop. And she kept looking in the scriptures for justification on murder. And she found it, in her words, that if someone did you wrong 3 different times, that you could kill them, which of course is not true. And now Phoenix police has agreed to look again at Joseph Ryan's death.
Joining us especially in Terry Austin's absence is attorney Julie Rendelman. So Julie, at this moment, neither defendants are charged with murder in any deaths. Could that shocking recording come into the trial Vallow and her current husband are scheduled to face for hiding the bodies of the 2 children?
So, look, I mean, this is once again, we know this woman is surrounded by death, and it starts to become a pattern of events where every person that she seems to touch or know ends up in a grave. And I think what's troubling about this is the fact that, you hear her basically finding a reason in the scriptures to kill her husband, and one wonders what she may have found in the scriptures to kill her beautiful children. Will it come in? There's going to be an issue of whether the probative value outweighs the prejudice. I think the prosecution does have some arguments, specifically in other areas that she talks about how she ended up in Hawaii. But time will tell whether or not they'll be effective in getting the judge to do that.
Yeah, questions of relevance and whatnot. So, Brian, do we anticipate murder charges ever happening here? And if so, how many?
I think from like a legal standpoint, you can't really anticipate. You've got to wait till you get the facts. But from a layperson's perspective, there's only so many bodies that can be buried around you until one of them ends up being a murder charge against you. And I think it's a matter of when rather than if at this point.
Many questions surrounding this case. Will continue to follow it here at the Law and Crime Network. Yet another court hearing to discuss now in the ongoing saga of convicted wife killer Scott Peterson. A jury sent Peterson to death row for the 2002 murder of his pregnant wife, Laci. But California appeals judges ordered both a new penalty phase and a re-examination of the conviction itself. The issue is that a juror may have lied about her opinions and beliefs to get on the case and to ensure a conviction. So this hearing was about whether Peterson should receive a new trial. Among the issues is whether Peterson can be moved to the San Mateo County Jail in California while the process plays out. Peterson is at San Quentin right now, the state prison, and has been unable to speak with his attorneys in part because of the pandemic. So, Julie, that's what we learned from the hearing that he just faced. This process, though, of deciding whether or not the whole case needs to be done over again is dragging on and on and on. When are we going to get a decision here?
So look, we have a decision regarding the sentencing, and we know that based on the fact that the judge kept out those jurors who didn't believe in the death penalty, but yet were willing to apply it, he basically said, you cannot be on this case. And what the defense counsel is saying, well, doesn't that kind of impact on top of the other potential jury misconduct? Doesn't that impact the entire trial? Isn't that an issue when it comes to these jurors sitting on the guilt phase? And that's what he's dealing with now. Now, keep in mind, the pandemic is slowing down everything. So it's not surprising that this would still be an issue that, hasn't been resolved. I'm not so sure he's going to be successful at the end because a lot of the case law doesn't seem to be in his corner.
Okay, so Brian, does this process make sense? We've got a definite new penalty phase and a possible entire new trial.
Absolutely. I mean, wherever you fall on the scale of Scott Peterson is guilty and should be put to death, or Scott Peterson, there's some sort of reasonable doubt, I think we can all share the same idea that due process needs to be kept here. And if we're going to kind of write that final note of putting him to death, we have to make sure that all the boxes are checked and we did it the right way. Otherwise, the system isn't working.
Well, a decision is, of course, forthcoming one of these days in whether or not the entire case will have to be done again. And still ahead here on Law and Crime Daily, an update on the case against Jacob Blake, who was shot and paralyzed by police in Kenosha, Wisconsin over the summer. Plus, measures to reform the way police departments operate in several major cities, passed during the 2020 elections. We explain what changes are in store and why they're important when Law and Crime Daily returns in just a moment. Welcome back, everybody. Voters in several cities passed police reform measures as part of the 2020 election. Brian's here with a look at some of the changes. Brian.
Yeah, and so here are just some of the measures which passed. Voters in San Francisco voted to abolish mandatory staffing laws, which actually required a minimum of 1,971 officers to be on the force at any given time. In San Diego, voters passed a measure to create an independent police review commission. In Pittsburgh, voters expanded a citizen police review board, and similar oversight measures passed on the ballots in Columbus, Ohio, and Philadelphia. Emily Galvin-Almanza, CEO and founder of Partners for Justice, spoke with me about many of these changes. Can you talk to us a little bit more about what exactly a civilian review board is?
Absolutely. So a civilian review board is an incredibly important tool for a community to have in controlling the way they are policed. All too often, as we know, police don't do a great job of policing themselves. They don't police themselves, or they let themselves off the hook. So the Internal Affairs Bureau of a police department may not be holding officers accountable for abusive actions towards the citizenry. A civilian review board is a group that gives the citizenry power to investigate police, to hold police accountable. Now, it's a really broad range of what powers they can have, but when a civilian review board is given certain powers, like many of the ones you just mentioned were, the power to subpoena officers, the power to perform investigations, to have legal counsel, and sometimes even the power to hire and fire officers in the department, that can really protect people against police abuse.
When you see numbers like this, voting on things like civilian review boards, what do you think the people are really pushing for? And do you think this can expand to other cities in America?
People who worry that talking about policing at all, or stepping back from our current model of policing is a political third rail, should look at these numbers and really reflect on the sort of astonishing majority support that measures to rein in police have gotten.
And some of these civilian review boards basically some people would argue, are just a rubber stamp from the internal investigation from the police department. So if they don't have the teeth or really the ability to do what you and I are talking about here, is there really a point for those types of civilian review boards?
That's a real danger. And we've seen review boards without power pop up across the country. And that's not to throw any shade on the incredible people who have worked on those review boards. Those people, by and large, have wanted more authority and wanted more power to do good in their community. But in the past, we've seen a lot of civilian review boards that, for example, did not have the power to subpoena police, did not have the power to fully investigate the complaints that were being brought to them by civilians. In other words, you'd have a civilian saying, hey, Officer, Jones beat me up and beat my brother up, and I know 4 different people who he beat up, and he planted drugs on my sister. And the civilian review board wouldn't be able to look into Officer Jones's other cases or check on whether prosecutors had been dismissing a large number of his cases because there were problems, or subpoena medical records if they might need to verify those claims. And without the power to take action, this is, again, a body with no teeth. You can find misconduct all you want. If you don't have the power to act on it, that increases the police feeling of impunity that has already done so much damage to their behavior and the way they police communities.
Many officers and sheriffs are saying, we don't have the money to prop up this civilian review board. Let us do our own internal reviews. This is a redundancy. We already have these reviews. Let's not spend more money. So what do you kind of say to that argument of, we could do it ourselves, let's save money and put it elsewhere?
I would say if they'd been doing it themselves, this conversation wouldn't be happening.
Fair?
Sorry. I would also say that, it is demonstrated that the police are not doing a good job of policing themselves. That ship has sailed. When a bad acting police department gets sued, and they do get sued, they are paying out millions and millions and millions of dollars a year to settle these suits. Now, where is that money coming from? Is it coming out of the police budget? Usually not. Astonishingly, very often when police do something wrong and they get sued and the court says, yeah, you guys screwed up, and orders them to pay, $5 million to an aggrieved family, that money comes out of the city's general coffer very often. So taxpayers are paying that money for bad acting police. Police don't sacrifice their budget when they act badly. They don't lose any money. So this goes back to not having any consequences and not having, being able to proceed with impunity. A tiny fraction of the amount of money that most of these departments pay out in settlements is all that's required to robustly fund a civilian review board. And what can that review board do? Clean up the department, ideally. If they're given real power and real investigatory capacity and the power to hire and fire, they can actually get rid of some of the officers who are most responsible for costing taxpayers millions and millions and millions of dollars because of their abuse.
Brian Buckmire there, along with the CEO of Partners for Justice. And coming up after the break, a sudden end to a case against a man shot by police in Kenosha, Wisconsin. And later on in this broadcast, the second phase of the trial against a pro baseball player accused of triple murder with a bat. A jury must decide whether the defendant deserves the death penalty. The Kenosha, Wisconsin man shot by police last summer will not go on trial as planned to face sexual assault accusations. Law&Crime's Angenette Levy is live with an update on that case. Angenette?
Well, Aaron, when Kenosha police confronted Jacob Blake last summer, you'll recall that he was facing a sexual assault charge involving the mother of his children. That charge has now been dropped, along with a criminal trespassing charge as part of a plea agreement. Now, Blake has pleaded guilty to 2 misdemeanor counts of disorderly conduct and will spend 2 years on probation. He became known across the country after he was shot in the back 7 times in August by Officer Russon. That happened after the accuser in Blake's sexual assault case called police, reporting he was on her property when he shouldn't have been. That officer claimed he thought Blake was trying to kidnap one of his children as he ducked into his car, and that Blake had admitted he had a knife, which was later found in his vehicle. However, Blake's attorney denied he had been carrying a knife. The shooting left Blake paralyzed from the waist down and sparked nights of civil unrest in the city that became violent at times. 17-year-old Kyle Rittenhouse is accused of killing 2 men during those protests. He claims he acted in self-defense. Now, the U.S. Justice Department launched a civil rights investigation into the shooting, and the Wisconsin Department of Justice investigation into the shooting and the officer's actions is ongoing at this time. Aaron?
Angenette, thanks a lot for the update. So, Brian, any surprises here legally? About 2 years of probation for a couple of misdemeanor pleas?
Not really. I mean, I know for our network, we typically see the big cases, the murders, the rapes, the big names. But when it comes to charges like this, 9 times out of 10, and I'm sure Julie will agree as well, we often find ways of taking plea deals, and probation for something along like this nature seems correct when I only have so many facts.
So, Julie, you're a former prosecutor. Do you think the shooting influenced prosecutors in the way they offered the deal in this case?
I don't. And, I've read a couple things about it. It seems to me that the reason that they lowered the offer was because the complainant with regards to those specific allegations wasn't being cooperative. And so they wanted, to get something. And so they went for these 2 misdemeanors instead of the sexual assault cases that were originally charged. And so the fact that the complainant didn't want to participate goes a long way in a prosecutor making a decision, to try to resolve it with some type of resolution, some type of plea.
Julie, Rendelman and Brian Buckmire, good insight on what happened behind the scenes potentially in that case. A couple of quick updates now on other cases we're following. New Mexico State Police announcing the arrest of 27-year-old Candy Jo Webb. They say she loaded her grandfather up with Xanax and Ambien to kill him. When he was dead, she loaded his body into a tool chest and dumped it. U.S. Marshals caught her on the run in Jacksonville, Florida, and took her into custody. The St. Louis couple, seen pointing a handgun and a rifle at protesters outside their mansion this past summer, is suing a photographer. Mark and Patricia McCloskey say the news photographer who captured the most famous images of them was trespassing on private property in their gated community and caused them, quote, humiliation, mental anguish, and severe emotional distress. And when we come back here on Law and Crime Daily, we're back to California as prosecutors seek the death penalty for a man whose attorneys say has a mental health issue and an episode was behind a triple murder. Brandon Willie Martin beginning court with his head in his hands. The former pro baseball player standing convicted of a triple murder. The jury found Martin guilty of slugging his father, his uncle, and a security system installer to death with his own baseball bat. Martin now faces a possible death penalty in a second phase of his trial. Prosecutors asked the jury to consider the brutality of the attack and how defenseless the victims were when recommending a sentence.
We consider Rick Anderson, the uncle, hit by surprise in the back of the head. We consider Barry Swanson coming to Mr. Anderson's aid and getting beaten time and time and time again. And of course, you can consider Michael Martin, an invalid, watching and waiting. Ricky Anderson was still alive when he went through Rick's pockets. As he lay there dying, and rummaged through his pockets, rummaged through Michael Martin's pockets and Barry Swanson, stealing their personal belongings. That's a circumstance of a crime that shows a callousness on the part of the defendant. And then, to add insult to injury, he drags his own dad's body into the garage.
The defense said their client is mentally ill and therefore should not be executed.
Everyone in the family, they don't know what to do. Many folks thought he had a drug problem. John believes he's got something more than that. Take him to see Dr. Balfour. On January 12, 2013, that's the first appointment. About a month later, February, he's diagnosed as schizophrenic, paranoid, and he's given Abilify, antipsychotic medication. She's going to come and tell you that. Look at the date. That's about, call it 2.5 years before murders in this case. That's important because he was suffering.
So, Julie, here's the big question. Should the alleged mental illness that's proffered by the defense nullify the prosecution's attempt to get the death penalty here?
So again, we talked about the death penalty, and here we have now 3 people dead, a brutal, brutal crime. But we also know that he had been in a mental health institution. They were supposed to keep him 72 hours. They decided not to keep him as long as they should have, even though the mother begged them to keep him, begged them, saying something is going to happen. And so I do think a jury is going to sit there and say, it is a brutal crime. He's responsible for it. But the mental health mistakes, the mistakes of kind of society and not handling it will have a huge impact on whether or not this specific individual should be put to death.
I mean, for civil liability, we have a very different argument here. But for criminal liability, Brian, do you agree with Julie?
Absolutely. I mean, call me old school. I don't like the idea of putting people with mental health issues to death in this country. I think that should be a point here, that the prosecution should not be seeking the death penalty when we have such clear evidence that would suggest, I know it's not proven as yet, and it may not be proven, we haven't seen that as yet, but even the suggestion that there was some serious mental health issue, I think that should be taken off the table. And then you look at this case, I think this family's had enough death in the family. Let's not add to it.
Many opinions about this case, and certainly the jury will get the last word. Remember, of course, there's a moratorium on the death penalty in California, so even if the jury hands out that punishment, the governor's order prevents it from being carried out. Julie, appreciate the guest appearance here on Law and Crime Daily. Brian, thanks again, as always, for being here with me. We'll be back again tomorrow with Terry Austin as we discuss justice in America right here on Law and Crime Daily.
Hi, I'm Dan Abrams. In the exploding legal and true crime genre, Law and Crime is the only network that has it all.
Good evening and welcome.
This is a complicated case.
Don't really jump to conclusions.
We break down the case of a serial killer.
Another day of drama between both sides.
From multiple live trials daily to original and compelling programming, the Law and Crime Network is everywhere, and we invite you inside the jury box. This is Law and Crime.